through an agency who has no professional qualifications in law or in medicine, and they have no professional ethics either, and are not regulated by any society, I'm not sure what safeguards the agency would put if someone goes through an agency. And I've seen this often where the intended parents have had a child with a surrogate, and then they approach me as an advocate to help them with the legal procedure. And of course, I will ask them, what kind of an agreement did you enter into? Can I have a look? And normally they're very, very basic agreements that does not protect the surrogate. So there is a difference if the agreement is done by an advocate who sees the parties and knows what they are doing, or if the agreement is done through an agency. The agreements that are done through agencies are also prepared by advocates. What I'm not sure of is whether the advocate prepares them separately and gives them to the agency so that the surrogate signs, or if the agency makes the advocate meet the surrogate one-on-one so that they are taken step by step and that their wishes are also recorded, or so that some safeguards can be put in the agreement. So there's a huge difference on how the agreement is done and with whom. Interesting perspective there, Advocate Dulio. I know you've mentioned that in the legal context, there is what is made to ensure that surrogacy is not a cosmetic procedure. That is to ensure that a couple are indeed battling with infertility. But what is the eligibility criteria for surrogates to ensure that maybe exploitation does not happen when choosing a surrogate? Okay, before I answer on what the eligibility criteria is for a surrogate, I wish to add that infertility is not the only reason why someone would opt for surrogacy. It could also be a medical condition. We've had people who probably they've gone through some form of cancer treatment, so their uterus is okay, and they are still able to produce eggs, but then because they've had cancer or any other medical condition, or they're going through treatment or have finished treatment, they're told, should you get pregnant, you are going to increase this and that levels in your body, and it will make you at a risk again. So it's not just because parties are facing infertility issues that makes them go for surrogacy, IVF and surrogacy, but that is one of them. Now, to your question, what are some of the eligibility criteria on surrogates? One, you have to be an adult, meaning minimum age will be 18. Though ideally in Kenya, I see most clinics, they want a surrogate to be between 24 and 30. Some of them go as far as 35. Two, you must have at least had one live birth and a child, and if you had a live birth and unfortunately your child died, then the circumstances that led to the death would be important. If the child was okay and probably died through an accident, then it will be considered, your case will be considered differently as opposed to if you had a stillbirth or your child died of a genetic condition. Then they would also check, have you been a surrogate before, and how many times have you been a surrogate? If you've been most of the clinics in Kenya try as much as they can through the database, if the surrogate has been with them before, that you can only carry a child through surrogates at least twice, not more than that, because some pregnancy may end up in you delivering through CS section, so you can only do it twice. And of course, they will also check your medical history. Those are some of the eligible criteria. What is the medical history of the surrogate? And of course, you also have to have had, they will also check criminal background, because they wouldn't want to have a surrogate carrying a child for someone, often a stranger, when this surrogate has a criminal history. Maybe she worked somewhere as a nanny and was prosecuted or charged or suspected of an abuse. So there are several eligibility criteria. Those are the ones I'll mention for now.
Okay. Now, what are some of the emotional consideration for both the parents and the surrogates during the 9 months of pregnancy? Because the surrogate in this case, there are cases that you witnessed, they will say that bonding when it comes to pregnancy starts with the conception stage. So there should be emotional, there should be some sort of therapeutic assistance for both parties. How is it done during this 9-month period?
Okay, what I know of, even before the transfer takes place, when I talk of the transfer, is the transfer of the embryo into the surrogate, there has to have a psychological check. I mean, parties have to bond. This is someone who is going to carry your baby for 40 weeks. So the bonding process has to start even before the pregnancy, even before the agreement, when you meet for the first time. And when you start talking with the surrogate, this is when you will also be able to pick up any red flags. I would like to mention a case where a few weeks ago, I was approached by a would-be surrogate, a would-be IP, and we were doing the interview for the surrogate. And what I noticed as some of the red flags is the surrogate, with each question, she kept on increasing her fee. With each question, she kept, or rather than answer us, she kept on asking more questions. And she was also very much concerned that, even on the nationality of the IP. So I picked those as red flags, because if we are not able, if an IP and a surrogate, they're not able to reach a consensus even on the initial stages before they go for the embryo transfer, then those are red flags to pick out. I do not think that it will change. If we do not have, if we're not communicating, whereas the surrogate, yes, they are looking at the compensation, but they forget that for the IP, they are interested in having a baby. Yes, your compensation is important, but don't lose sight of the fact that we would want to have a baby. We want someone who will be comfortable carrying our baby. We want someone who will not use the pregnancy to manipulate us, that if you don't do this, I'll not do that. So as an advocate, I'm able to pick this, and also the clinics, the fertility clinics where the IPs go to and the surrogate, those doctors normally insist that they go for psychological evaluation, so that the surrogate, whereas they know that they don't have any genetic link with the baby, but the baby will be kicking inside them, they will bond, but they will have to surrender the baby as soon as the baby is born.
Okay.
Thank you.
Thank you, Advocate Dulo, for that particular perspective. We'll be taking our first break, but don't go so far. We'll be back with more.
They speak to play politics.
Kila mara yeye ananiwinda kama mnyama. Naambia yeye Mungu iko. Mungu iko na sitarudi nyuma.
They speak words strong enough to change policy and the law.
We have a very democratic system. We have a system that is based on the rule of law.
They speak to the heart of the nation, for the nation.
Simu imeleta mambo mingi sana. Mimi hata nataka ifungwe kabisa, na ifungwe hata WhatsApp na Facebook zifungwe kabisa.
When facts get lost in all these words, we aim for the truth. Join me, Dennis Omondi, every Tuesday night at 9 p.m. as I serve you the news and speak to your leaders and their observers to establish nothing but the truth, only on KUTV.
Focus on Health is a show that creates awareness on matters health and informs you on various diseases, their causes, treatment, prevention, coping, and support. So join me, Bwari Michelle, every Thursday at 7:30 p.m. only on KUTV. You can also follow us on our social media platforms at KUTV Focus on Health on Facebook and also on YouTube, and Health Focus on Instagram, because your health is your wealth. Stay safe and stay healthy.
Kipindi hewani ni mitindo ya kipwani. Kama ilivyo kipindi hiki kinahusu nyimbo za taarab, chakacha, midwara, midundiko, bila kusahau mapishi. Ambao ndio uti wa mgongo wa pwani ya Afrika Mashariki.
Jamani, swahibu zangu mliopo maskani, hatuonani wenzangu, najua mwanitamani.
Hapa KUTV, nahodha mwendesha chombo cha baharini, yani ua linalunukia na kuvutia waridi tamu.
Thank you for staying tuned. You're watching Law Matters. Tonight we are having an interesting discussion concerning surrogacy in the country and what are the legal context on that. We are having Advocate Dulo debunk the issue of surrogacy in the country, which has raised questions and controversies on the same breath. Now, Advocate Dulo, once before we went on a break, we were talking about the safeguards and the red flags when it comes to choosing a surrogate. Perhaps, what are some of the safeguards that, parents in this case should take a keen concern on when choosing a surrogate to avoid investing in something that will not see fruition due to, say, being exploited by the surrogate in this case?
Okay, some of the safeguards since I've been in practice, and I've been in practice in this for about 5 years now, and I've seen the highs and the lows. I think it's very, very key to have a legal consultation before you enter into the agreement. Before you do an agreement, do a legal consultation. Don't just have the surrogate sign. If they do a legal consultation before an advocate, then the advocate will take the surrogate step by step. Whereas it is true that we don't have legislative framework, but the agreement that they are signing is a contract. So you have to tell them this contract is binding. It's binding on the surrogate, it's binding on the IPs. Before you even reach the stage of the agreement, you must have interacted. You must have agreed on the terms. You must have agreed on what kind of compensation are we going to be giving the surrogate. You must have agreed on the kind of engagement that you'll be doing with the surrogate. This is when I talk of engagement, is communication, hospital, and all that, so that you protect yourself as an IP and the surrogate is protected. And remember, the surrogate is going to be carrying your baby for 40 weeks. So you need a good relationship where you can call them, they can call you. It's not restricted. So it's important that you really get to know each other before the transfer process is done. Okay. Thank you.
Is that to say that the test for parents in this case is finding a good advocate or good legal advice to ensure that there are no loopholes that might come out to the extent of being blackmailed in the process?
It's not just about finding a good advocate. It's also finding an advocate who knows about IVF and who knows about surrogacy. Any advocate knows, any advocate can talk to you about a contract, on what makes a contract void or voidable, and if there's breach, what to do. But remember, this is a niche area in family law practice. It's an untraditional area, and also we do not have legislative framework. So for us who are self-taught on surrogacy, we have studied the law in several other jurisdictions. We have also done case law. So you do not just need a good lawyer. You need a lawyer who knows the law on IVF, who knows the law on surrogacy, and a lawyer who knows where to find that law.
Okay. Now, how is the medical screening and selection process for surrogates undertaken? I know it's more of a medical question than a legal question, but we have had cases of an omission by a doctor costing the process altogether. How is that medical testing done within the context of the law?
I'm afraid I will not be able to answer that. As you've mentioned, it's more of a medical question. Mm-hmm. I'd rather stay safe with what I know.
But do we have cases whereby a parent can sue a medical institution in cases of omission?
If there's a breach of contract, yes. Remember that the IPs, that is, when I say IP, I mean the intended parents, they normally enter into an agreement with the fertility clinic in as much as they also enter into another agreement with a surrogate. So where there is a breach, rightly you can and you should sue for compensation.
All right. Now, when it comes to the financial aspect, which many have raised questions on, given that IVF is quite an expensive process, how is the process of compensation and expenses done? Does it vary depending on the contract? Is it outlined in a specific manner depending on how the agreement comes into place?
The amount of compensation that surrogates get is dependent on how deep the pockets of the IPs are. And I also want to debunk the myth that IVF is done by wealthy people. IVF is done by intended parents who really wish to have a child that they have a genetic link with. Remember, adoption is also an option, but adoption does not give you a child that you have a genetic link with unless it's kinship adoption. Some people take loans. Some people go for their relatives to be the surrogates because with their relatives, they're able to negotiate how much compensation should they pay. So I would say on a minimum, I normally advise IPs on a minimum, give the surrogate a minimum of $500,000 as compensation. And this excludes the medical fee, which has to be paid for directly by the IPs.
Okay. Now, let's now focus on the surrogates and the child in this case. Given that you mentioned that the issue of surrogacy does not bind any particular nationality from seeking a surrogate in the country, there's been a question of the nationality of a child, with cases being cited that in situation whereby a foreign couple seeks a surrogate in the country, they have had hurdles registering the child as a nationality of, say, Britain or United States. But in this particular example, it was in Britain. What is the requirement when it comes to the issue of nationality of the child, given in cases where the child is born in Kenya?
Well, the good thing is that our constitution recognizes dual nationality. So if the IPs are not Kenyans, but they had their child in Kenya, if the country that they come from or where they hold their citizenship recognizes dual nationality, then they can elect that their baby will also have Kenyan nationality in addition to theirs. However, where their country only recognizes one single nationality, then, it's logic that they will seek only the nationality of their country. Where a baby is born here and the IPs don't live in Kenya, they're not habitual residents of Kenya, they will go to their embassy to get the process started. Now, in my case where I am consulted, I am the advocate handling the matter. If the IPs are not Kenyans, the first thing I will ask them is, what's your nationality? The reason I do that is I will study the law in your country to establish if your country has legislation on IVF or not. And if they do, then what is the acceptable practice there? So that I do not approach the courts in Kenya and get you orders where when you go to your embassy, like happened in the British case, you are told they do not conform to the practice in the UK. So if you are my clients or where the IPs are not Kenyans, the first thing I will find out is what's your nationality. Does your country have law on surrogacy? If it does, I will go online to check, and I will also ask you to link me up with an advocate or a solicitor or an attorney in your country so that they can expound more. Because remember, the child is born in Kenya, you want the child to have your nationality, but for them to leave Kenya, our immigration will have to be involved. Your embassy will have to be involved. Some embassies or high commissions will insist that you get a court order from Kenya before they process the travel papers. Other embassies will not. But it's important when I do my research, knowing your citizenship, so that I can advise you on a case-to-case basis. So nationality of the child is never an issue. Where the child is born is never an issue. What the IPs need is an advocate who knows the law on surrogacy.
Okay. Now, what are the provisions for commercialized surrogacy to ensure that the surrogate is not exploited? In this case, what I mean is, if the parents in this case come with the advocate, is the surrogate allowed to come with their legal counsel, with the rider that most of these surrogates come from poor backgrounds, therefore they cannot maybe afford a legal counsel to represent them in the negotiation? How is that balanced, given that one party appears to be advantaged compared to the other?
In an ideal situation, both parties should be represented, and it should be the intended parents who bear the cost of the legal counsel for the surrogate, so that the surrogate also has her interest, where she can ask her lawyer for advice and trust that because this is my lawyer, they are not representing me and representing the IPs, they have my interest singularly at heart. So it's important that to protect the surrogate, they have their own advocate paid for by the IPs. Well, and I've also met surrogates who tell me, I've read about this online, I know about the process, or if you meet surrogates who've carried a child before, then they'll be different from a would-be surrogate who it's their first time.
Okay. Now, in the 5 years that you've handled the practice of IVF here in the country, I know you mentioned that the surrogate can only be allowed to carry 2 pregnancies in this particular medical procedure, but have you witnessed the issues of a surrogate taking multi-pregnancies, especially in the agency's kind of business interaction, that are not exposed to maybe the legal framework that will now call them out? Do you have cases of such exploitations you've witnessed?
I've not seen that in my line of practice. However, I will not rule it out. Mm-hmm. Yes. So remember also that when IPs or surrogates go through an agency, the agencies have their set of advocates. It's only in instances where the IPs insist that they are going to hire their own advocates is where I or other advocates who are doing surrogacy get to be hired for the legal representation. Okay.
So what are some of the surrogacy procedures that, border human rights violation, especially when an agreement has been, the 2 parties have had an agreement and now the process has commenced in terms of the gestation period? What are some of the surrogacy procedures that will scream human rights violation?
And this also happens only where it's an agency involved. The fertility clinic or the lawyer are not involved. Where the agency, first, they don't want to link the surrogates with the IPs. Secondly, where once pregnancy is confirmed, the agency takes you as the surrogate together with other surrogates, and they provide you with accommodation. I don't know how safe or how human those accommodations would be, and why you'll be insisting, that you are providing someone with accommodation.
Okay, in cases whereby the surrogate decides in the middle of the gestation period to terminate the pregnancy, what are some of the legal backlash that are associated with that? And will the parents still cater for the medical expenses to terminate that particular?
I'm sorry, would you kindly repeat your question?
I'm asking, in cases whereby the surrogate decides to terminate the pregnancy, what are some of the legal backlash that the surrogate might face? And who caters for the expenses when the surrogate decides to terminate the pregnancy?
Oh, remember, the law as it is in Kenya does not provide for provide for abortion unless there's a medical reason. So a surrogate cannot on their own decide that they're terminating the pregnancy. If there's a medical reason, then it is the doctor. And this is, when the surrogate is pregnant, they'll be attending clinics to see the obs-gyna. And so unless it's the obs-gyna that has made a recommendation that the pregnancy needs to be terminated, and with reasons why, either the surrogate's life is at risk, is in this instance the mother, or the fetus is at risk even if the pregnancy proceeds to full term. But the law in Kenya as it is, you do not have a right to terminate a pregnancy without a medical reason. And of course, even the surrogacy agreements normally do capture that. So there are jurisdictions where abortion is allowed by law, but not in Kenya. So a surrogate deciding that they are going to terminate the pregnancy, they will not only be breaching the agreement that they made with the IPs, but it will also be an offense in Kenya.
Okay. Now, in situations whereby maybe the parent in this case is a gay couple or a lesbian couple in a country whereby homosexuality is not per se condoned, can the surrogate find herself in the wrong side of the law for carrying a pregnancy for a homosexual sort of couple?
I don't think the surrogate will find herself on the wrong side of the law, because probably she didn't know that she's carrying a baby for a same-sex couple. Example, if it's gay or lesbian and it's only one part to the relationship that approaches them, and it's her eggs being used, but they'll be using donor sperms, or the surrogate will not know. However, the surrogate would be suspicious if it's a man who approaches her, because ordinarily she would ask, why would a man on his own want to have a child with the woman? And on this is where also we need regulation so that we are very clear. Whereas the Constitution recognizes the right to reproductive health services and that everyone has that right, the same Constitution recognizes the right to found a family, and marriage is only between man and a woman, not same-sex couple. So, without legislation, we still have a lot of these loopholes that happen, and they'll continue to happen because of the gap in legislation. That's all I can say.
All right, Advocate Dulo. We'll be taking a break, but once we come back, we'll be looking into the legal loopholes that the advocate has touched on, and much, much more. Stay with us.
First time?
Yeah, I'm kind of scared, but I can do this.
Yeah.
Mess with me. Yeah, let's do this, man.
Welcome to Children's Corner. Welcome to
Children's Corner.
Children's Corner. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 116, 117,
man. To him, women are just like pieces of meat. And worse, he makes them fall in love with him and leaves them heartbroken. What kind of man are you?
The first time I saw Dylan, I knew we'd be together forever and ever. It's destiny. He loves me. We'll make a family. Who is Nambi? Nobody.
If you Ziwa think you're man enough to step into my shoes, then be my guest and take a minute.
Thank you for staying with us. You're watching Law Matters. Tonight we're discussing the issue of surrogacy here in the country without a legal framework guiding it here. What are some of the loopholes? And this is the final segment in that particular discussion, of course. Bringing the discussion home, we're having Advocate Dulo join us tonight. Now, Advocate Dulo, when it comes to surrogacy and the process has commenced, that is the two parties have come into an agreement, the parents and the surrogate in this case. What happens when the parents decide to divorce and they are waiting, a child is on the way? What happens in that scenario?
Well, first and foremost, it would be unfortunate, but it does happen. I will share briefly on a case law that happened in India, but it does happen. If that happens, one, you'll just have to wait first for the baby to be born, whereas life begins at birth. Probably there'll be a dispute on who continues to pay the surrogate. So if that happens, the surrogate will cite both parties to breach of contract. And in all contracts that we do, we also make the IPs know that the product of this agreement will be a child. And this child has all the rights as provided for under the Children Act and under the Constitution. Now, there's a very interesting case, I think Baby Mwangi case that happened in India. What happened is Dr. Mwangi, Japanese, and his wife had gone to India way before India banned international surrogacy. So they'd gone to India to get a baby through IVF because remember, India was then known as the baby factory. So they went, they had the IVF process, engaged a surrogate who got pregnant successfully, and they went back to Japan. So during the duration of the pregnancy, something happened between Dr. Mwangi and the wife. They separated and eventually even divorced before the baby was born. Dr. Mwangi had a genetic link with the child. The wife did not. They used donor eggs. So because they had been divorced, when the baby was born, he went to India on his own to get the baby. Going to India on his own, first India, then, and as it is now, they do not provide or recognize dual nationality. And they also don't recognize male adoption, despite the fact that this was going to be genetic. So the question was, how does, what rights did Dr. Mwangi then have to be able to get immigration documents so that he can leave India with the baby? His mother had to go to India, stay for about 8 months looking after the baby, as the advocates in India tried to work out this legal jargon because they had not faced this before. Eventually, the government of India, based on the best interest of the child principle, agreed to give Baby Mwangi exit documents so that she could leave India with them father and go back to Japan. So in any case, if parents separate or divorce, the parent who did not have a genetic link to the child cannot claim that they do not have any obligation or parental responsibility to the child because the relationship has gone south and they did not provide either their sperm or their egg. The agreement that they signed will hold them, will bind them, and remember also, it is the best interest of the child principle that is paramount. So it is not that parent's interest or right. The child's interest has to be paramount. So in a nutshell, the law in Kenya as it is, it's sufficient and it protects children. The parent who's left with a child or the surrogate just need to know on how to seek remedy so that they can get the child's rights protected. Thank you.
Okay. Interesting there. When it comes to the issue of nationality, going back, in cases whereby countries do not accept dual nationality, and maybe the child was named, the citizenship of the child was, say, Kenyan, and now you're moving to, say, United States, and you find yourself in a situation whereby maybe you might be forced to adopt the child, and the child is already yours by given the aspect of genetics. Is the adoption process made easier given that this is your own flesh and blood?
Well, you've asked two questions. You've asked on citizenship, nationality, and adoption through surrogacy. I mean, where you get a child in Kenya and you are from a country that does not recognize dual citizenship, then obviously, because you are not living in Kenya, there would be no point in you having your child take on Kenyan citizenship. And if that happens, all you do is just you relinquish the Kenyan citizenship so that your child can have your country's citizenship. And this is easily done through the high commissions or the embassies, whichever representation that you have based here. Adoption is not necessary. I'd give you the example of the UK and Australia because these are both common law countries. In the case where there's a case that was decided in our High Court where the British Embassy had declined the couple from registering them as British citizen because the legal process was not as per the British law. Parties went to I'll just summarize. The IPs, after getting their children, got them Kenyan birth certificate and Kenyan passport, and they registered them in their name in Kenyan birth certificate based on a legal opinion that the Attorney General's office had given to KNH where the children were born. And then they got them a birth certificate. So about a year later, when they go to the British Embassy, because they were Kenyans but residing in the UK, they go to the British Embassy and presented these documents as the children being theirs. But then the British Embassy said, no, wait a minute. In your travel documents a year earlier, when you flew from the UK to Kenya, there was nothing in your travel documents that stated that you're pregnant. So how did you get these children? So they disclosed that we got the children through IVF and surrogacy. So on that basis, they were denied because in the UK, when you get a child through surrogacy, they have a two-tier, it's not a two-tier process, but they have two processes. Either you go to the family court from when the baby is 6 weeks to 6 months and have the transfer, the parental orders made from the surrogate who is recognized as the birth mother. The birth mother is recognized as the legal mother. And if the birth mother had a partner or a husband, is also recognized as the legal father. This is the same procedure in Australia. So you go to the family court and apply for parental orders with consent, of course, from the birth mother and the legal father if she had a man in her life, either as a husband or as a civil partner. And you do this when the baby is between 6 weeks to 6 months. If after 6 months is when you decide to start the process, then you have to go to the High Court and seek adoption.
Okay.
And so in the instance where the British Embassy, in this Kenyan couple, where the British Embassy refused to register them, the babies were at this time now 6 months old. As per the IVF and surrogacy law in the UK, after the 6 months and you got your children through surrogacy, the process is you go for adoption. So, I mean, they were kind of in a mix because remember that case came from the Human Rights and Constitutional Division. It didn't even come from the Family Division where adoptions are processed. Reason being, they already had the birth certificate and they already had the passport. Then you are telling me I need to go and adopt a child that already have a birth certificate for. So they had to go to that specific division for human rights and constitutional so that they get an interpretation, and it's those orders that help them now go to family division and get a fast track adoption process. There's nothing illegal that they've done. It's just that they were not residing in, they got the children in Kenya, whereas they were not habitual residents in Kenya, and they did not conform to the law as it is practiced in the UK, where they had intended to go to.
Okay. Now, Advocate, given that you've done this line of practice for 5 years, do you think that the more the country derails in terms of putting in place legal framework, the more it will leave us more exposed to exploitation and what have you, due to the dilly-dally in putting in place legislative framework?
I totally agree with you. It leaves us vulnerable. And remember, I don't know how much our members of parliament, both in the Senate and in the National Assembly, I don't know how much they factored in the economic, the economic that it will do to the country. Because remember, where we have foreign IPs, when they come in, right from when they are buying the air ticket, they are coming to Kenya. If they use KQ, that's a revenue to us. The taxi from the airport, taking them to their hotel, that's a revenue to us. If they check into a hotel or an Airbnb, that's a revenue to us. When they hire me as an advocate who returns a tax, that's an revenue to us, and even to the IVF clinic and to the surrogate. So they put in a lot of money in circulation, which part of it is our taxes, and it will also make Kere happy. Okay. And it will also, and where you fail to have legislation, you also make the children vulnerable. Why do I say this? We have the annual human trafficking report done by the US Embassy. Kenya, for a long, long time, we've remained on tier 2 watch list. And tier 2 watch list is, in football, it will be like the yellow card. We are not good, we are not bad, but it makes children vulnerable because Kenya is known as a source, transit, and destination country for human trafficking. Some IPs, to make it easier for them, when the surrogate goes to hospital to give birth, they do the direct transfer, where their attending obs-gyna knows that, of course, this is a surrogate birth, but the surrogate checks in with the intended mother's ID. So when the notification comes, it is the intended mother that is registered. But you see, this makes children vulnerable because it will also open an avenue for human trafficking. I know there've been proposals also that we use the agreement to do a direct transfer of this from the surrogate to the IPs, but where people check into hospital and with an agreement, but this was not a case of surrogacy. This is just a vulnerable woman who's gotten pregnant and someone has come that give me the baby and I will compensate you. I mean, they can cook their own agreement so that they give it to the hospital to do a direct transfer to them. Because there's no if there's no legislation, or if the legislation is passed with that, it puts children at a vulnerable position. Because in any IVF process, the end result is a child. So when I'm looking at the law, the proposed bill by Honorable Millie Odhiambo, I don't look at it with a gender lens. I look at it with a child rights lens. So it's important that we have legislation so that we protect the children, we protect their best interest, and we establish ourselves as a safe country for people who are not Kenyans, where they can come in and have children through IVF, through surrogacy. Thank you.
Okay, the final question, because you're pressed on time, what are some of the cultural and societal aspects that might hinder the process of legislative framework for surrogacy here in the country due to our culture?
On culture, it will be the stigma when you're not able to have a child. And remember, when a couple is not able to have a child, even without friends or relatives or those in your social network knowing what the problem is, fingers are always pointed to the woman, that she's the one who's barren. And it's even much more shameful when you realize that it's a man, because there'll also be stigma. And I mean, even in my mother tongue, the terms that we use to describe a barren woman or a man who's not able to sire, there's a lot of stigma associated with the terms. I mean, in my mother tongue, Luo, a woman who's not able to give birth, she's called Lur. A man who's not able to make a woman conceive is called, I think, botch. And I mean, they're very demeaning. So socially, there's still a lot of stigma. I know of couples who've had children through surrogacy, and they keep it wraps. They don't want people to know that they had children through surrogacy. I've had clients where we did not meet face to face. We did a Zoom meeting, and they kept their video off because they also still want to protect themselves from the advocate. Yes, they have shared their identity documents, but I didn't see their face. And we have 50 million Kenyans. Then, so that is socially, the stigma still puts people down. On legislation, the bills that is being considered, whereas a lot of work has been done with the members of the Senate and Legislative Assembly, when we first started, there was this belief that was being peddled that the bills are promoting abortion by choice and promoting or giving of contraceptives to even underage. So there was a lot of misconception and miscommunication that was then. I'm glad, and I know that that has now been removed, and the Kenyans were picking up. So it's important that we see reason. Parliament should see reason why they need this bill. I mean, adoption, people who adopt children have a right to maternity leave. If you have a child through surrogacy and you're living in Kenya, it will take the compassion of your employer and human resource managers to give you leave, whereas you need maternity leave so that you can bond with this child. And maternity leave, look at it also from the lens of the child, the best interest of the child. Those first few weeks of their lives is important. But when there's no legislation, you've had a child through surrogacy, the child is home, the surrogate has handed over the child, but I mean, what do you cite when you're applying for maternity leave or parental leave? So those are some of the stigma and the social issues that we're facing. Thank you.
All right. Thank you so much, Advocate Dulo, for making time and giving us a perspective concerning this particular issue that many have tried to understand for so long. It's a new issue, but we are getting to understand it more and more the more it's being practiced. Many thanks indeed.
Thank you.
That has been Advocate Dulo giving us the perspective. I hope you've been able to catch a thing or two concerning surrogacy in the country and what is being done and what has not yet been done. I've been your host, Irene Mwangi. Have a splendid night.